It's been over 5 centuries, almost 530 years, since white men washed up on the shores of this hemisphere with this nonsense. It's time that all those still propping up this house of cards let it fall. Although the doctrine of Christian discovery gets its start from the popes of the 15th century, it's all the rulings that use this thing in the U.S. courts that's problematic. Courts, including the U.S. Supreme Court, have asserted the doctrine of Christian discovery as a valid legal principle throughout the 19th, 20th, and 21st centuries. One case in particular that not only cites and defines the doctrine of Christian discovery is a 2005 case involving the Oneidas. In the city of Sherrill versus the Oneida Indian Nation, the Supreme Court reversed a lower court ruling and rejected the right of the Oneidas to reclaim land whose deeds they purchased as land under their governance and jurisdiction. The near unanimous vote had only one dissenting opinion. The affirming opinion was written by Ruth Bader Ginsburg. In footnote number 1, Ginsburg cites the doctrine of Christian discovery. She cites, under the doctrine of discovery, fee title to the lands occupied by Indians when the colonists arrived became vested in the sovereign, first the discovering European nation, and later the original states and the United States. She cited this from a 1985 case also involving the Oneidas, as a footnote when she writes that the Oneidas ceded all of their lands to New York State in 1788. Now, there is no attempt in this definition of the doctrine of discovery to explain how this fee title simply became vested in the discovering European nations, just that it does. This legal doctrine became enshrined in U.S. law under the Supreme Court of Chief Justice John Marshall in 1823 in a case called Johnson v. McIntosh. Marshall asserted that Native people did not and could not hold title to land, and that only the Christian nations of Europe could do so, at least initially. But he goes well beyond just a claim to land when he also asserts that discovery was the same as conquest. He knew it was a stretch to put it this way. So, this is how he said it. However extravagant the pretension of converting the discovery of an inhabited country into conquest may appear, if the principle has been asserted in the first instance and afterwards sustained, it becomes the law of the land and cannot be questioned. Now, this isn't just an extravagant pretension, it's absurd. So in other words, if you can make an absurd claim early on and not have it challenged, it just becomes law. But there are major problems in applying the doctrine of Christian discovery to the Oneidas. Marshall actually created this racist legal foundation and then weakened it with his extravagant pretension. Ruth Bader Ginsburg, the liberal darling of the court, seems to ignore that almost 30 years prior to Marshall codifying the doctrine of discovery into U.S. law, the United States clearly recognized lands occupied by the Six Nations, including the Oneidas, as lands owned and controlled by those nations. The language of the Canandaigua Treaty of 1794 stated 3 times that the United States acknowledged native ownership of land and that the United States will never claim the same nor disturb any of the Six Nations or their friends residing thereon and united with them in the free use and enjoyment thereof. So it appears that this principle was not asserted in the first instance, nor afterwards sustained. Ms. Ginsburg also cited a legal principle called the Impossibility Doctrine from a 1926 case, where the Supreme Court said it was impossible for the Yankton Sioux to assert control of land occupied by non-native settlements, regardless of how that settlement came to be. She actually had to stretch this one because the Oneidas were not asserting control over lands occupied by others. They had purchased the land, or rather, paid the non-natives to leave it. But the bigger problem here is that while Ginsburg cites the Impossibility Doctrine based on a case from 80 years prior and over 1,300 miles away, The U.S. Congress passed the Salamanca Lease Settlement Act only 15 years prior, relating to the Senecas only 200 miles down the road. This act included a provision that allowed the Senecas to reacquire lost lands with funds provided in the settlement. And these lands were not just lands held in trust by the federal government. These lands are reclaimed as original Seneca lands. Now, none of this changes a bad ruling, but it shows the weakness of the legal and ethical basis for them. It also shows the absurdity of them and the length to which political ideologies and culture can be stretched to maintain the status quo. Ruth Bader Ginsburg is praised as a liberal champion of human rights. She's Jewish and should have some sense of the plight of the oppressed and the displaced. But here you have this Jewish Supreme Court justice relying on a racist 15th century Christian dogma to make her rulings. If papal bulls from the 1400s can be enshrined in U.S. law, then why can't modern, internationally accepted standards unseat some of these extravagant pretensions? In 2007, the United Nations General Assembly adopted the United Nations Declaration on the Rights of Indigenous Peoples. The third affirmation of that declaration affirms that all doctrines, policies, and practices based on or advocating superiority of peoples or individuals on the basis of national origin or racial, religious, ethnic, or cultural differences are racist, scientifically false, legally invalid, morally condemnable, and socially unjust. Do you hear that, Miss Ginsburg? Legally invalid.